We were talking earlier about the exhaustive search for a similar health care provider, and that they would do everything they could, and at some point they would have to prove to a court that they had done everything. I never heard an answer specifically as to what is done to find out or reach out to a similar health care provider. Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, the way I would envision it and the way I would see that the plaintiffs and their attorneys would proceed is they would obtain a list to the best they can of similar health care providers, reach out to them, provide them with the material. First of all, they would reach out to them to contact them to see if they're even willing to potentially participate and submit a certificate of merit, but also if somebody was willing to do so, they would then provide whatever materials that they had so that the that similar health care provider could examine the materials and draw their conclusions.
Thank you, Mr. Speaker. And through you, when we're talking about making a list, I heard some information earlier that said there would be no number. Nobody could tell how many they had to put on this list or how many contacts they'd have to make. So through you, Mr. Speaker, is this something where they would make a list of 20, 30 and leave phone messages? Or would they do it certified mail? Through you, Mr. Speaker.
Representative Fox.
Through you, Mr. Speaker, it doesn't state the method, and it's difficult to state a number because different types of actions have different health care providers who are in the area in that specialty. I would say that if a plaintiff's attorney wanted to assert that they made a couple of phone calls and didn't get a response, that they would that would not be sufficient, and they should, if they would then sought to provide a certificate of merit from a healthcare provider who qualified under the other section, then I think that they may be at risk. So I would anticipate that the plaintiffs and their attorneys should make as much effort as they can within reason in order to satisfy the court.
Representative Carter.
Thank you, Mr. Speaker. You know, ladies and gentlemen of the chamber, as this amendment has unfolded, what would become the bill, I've looked at this and it doesn't make a lick of sense to me. And here's the reason why. Each one of us in this room has had at one point in our life a day job. And in our day job, we all are somewhat professional in our industry. We have licenses, we have expertise, we have something we do for a living that makes us special. Now, I put it to you for a second. What happens if somebody wants to sue you, and right now, the way the law reads, it has to be somebody in your specialty that is there to say, yeah, this lawsuit has merit. So if you're a tax accountant, guess what? It's going to be a tax accountant that decides whether or not you have merit. In this case, if it's a physician we're talking about, if it's an orthopedic surgeon, it's an orthopedic surgeon with the same specialty that determines whether there's merit to bring a lawsuit. That makes sense to me. In fact, it wasn't all this way. We heard testimony earlier, or I should say not testimony, we heard in the chamber, that back in 2005, they strengthened the law to put that in place. Now, there's a reason they did that. Malpractice suits were going through the roof. So what did this legislative body do? They said, you know what? It makes sense to have a difference between an expert witness and the person who brings merit to the case or decides there's merit. So at that time, an expert witness could be somebody, who's an expert in the subject area. That made sense. But you know what we're going to do? We're going to add on another level of protection to make sure that if somebody gets sued, it's legit. And what happened after that? Guess what? Malpractice suits went down. Lo and behold. So now we're back in this chamber today, and we're looking at this, and we're saying, well, wait a minute. Oh, it's too narrow. We don't have enough malpractice suits. Now we're worried again that, guess what? We need to open the doors and find a way because we're afraid patients aren't able to sue. And the bottom line is, There are people in this chamber who believe that, guess what? Patients do get their day in court.
15 minutes.
So why in a minute, if you're thinking about even yourself, why would you want to open the door for just anybody to be the expert witness against you? Now, earlier we talked, it was given that if you had an orthopedic surgeon who did spine surgery, you could have a neurosurgeon come in and actually do the testimony. Guess what? Neurosurgeons and spine surgeons are trained differently. Yeah, they might do the same kind of surgery, but guess what? They have a far different background. They have a far different focus. If we want to maintain what's fair about deciding the merit of a case, we should be comparing apples to apples. That's why we put this in place. Now, let's say today we decide who's going to be the loser in this. You know the loser in this? It's the Medicaid patient, guys. It's the Medicaid patient. It's the poor patient. It's a patient who we sit in this chamber day after day and we say we want to increase their access to health care. We have people in this state who don't have access. So what are we going to do now? We're going to make it even more difficult for doctors to practice medicine in Connecticut. You know, and some would argue it's the Medicaid patients or those patients who often sue the most. So think about it for a second. Our biggest looming crisis in this country, and certainly in this state, is access to health care. So what are we doing? We're turning around and we're saying, taking away a very common sense proposal that we put in place in 2005 to say we want to make it easier to sue. We're going to point the finger at the bad guy again, at the physicians, and say, you know what? We're coming after you. Now, ladies and gentlemen, I understand there are people out there who have things happen. Mistakes happen. And it's the law of statistics that says somewhere in the state of Connecticut or the United States, there's the worst doctor. And one of you might have an appointment with him or her tomorrow. But the bottom line is we have a good system in place that protects our citizens. It did what it was supposed to do. It lowered the costs. I should say it lowered the malpractice cases in the state of Connecticut. That's a good thing, folks. It's a good thing. I really implore you, as you sit down and you make this vote today, you think about what if you were in the same situation? Who should be making the decision whether or not somebody can sue you? Should it be somebody who knows how to do your profession, or should it be somebody who's just like you, has gone through the same training as you, maybe has the same license as you? Think about that, folks. It's common sense. We've also heard talk that this bill is a compromise. You know what? I talk to a lot of physicians out there who don't look at anything like this as a compromise. They're feeling the squeeze, folks. They're feeling it. And I know they're not going to look at this favorably when they turn around and go, oh, they're opening the door again? Because do you know what it takes when a physician gets sued? It could take years of upsetting their life. I know somebody right now, one of my very best friends in the world, he's going through it. And he's had to delay boards. He's had to delay things in his life, waiting and waiting and waiting. Now, I'm not privy to whether it had merit or not, but I know the effect of lawsuits. I know the cost of lawsuits, and so do you. So again, I implore you, think wisely about this. This is an important vote. Just like our colleague from Glastonbury said, this is a big deal, folks. Thank you very much, Mr. Speaker.